My name is Patricia Zugaby, and I'm the CEO of Holt Construction. Holt Construction is one of the country's leading builders, and we're especially recognized for our work in the aviation sector with a large portfolio in the Northeast as well as across the country. I'm very proud of our team and how we integrate small businesses into our projects. We have been working at Newark Liberty International Airport for over 30 years, and our offices at the airport are always open to you. Holt is very committed to diversity and including small and local businesses, especially MWBEs, local businesses, and veteran-owned businesses in our projects. Our work also supports local residents to help them build a career in construction. As many of you already know, this year we have launched a new program, Building Newark Airport Together. That features special sessions every Friday from noon to 1 p.m. These sessions provide you with important information about contract and career opportunities and will open the gate to building your business and your career with us. We are now in our third month of our program of Opportunity Fridays, and we continue to receive excellent reviews that our sessions are helpful and useful to many of the small businesses who attend. And that is our goal, to bring important information and new opportunities to MWBE and LBE businesses in the airport community. Legally protected companies. I won a contract. Now what? This session is focused on providing general information to subcontractors and smaller general contractors who will be self-performing specific trades. The focus will be in two parts. One, identifying critical basic parts of the contract, and two, the role of a construction attorney as part of the company's professional team.
Thank you, Patricia. I'm Alexandria Parati, and I'm so pleased to serve as your program host for our Opportunity Friday series. Opportunity Fridays are important sessions that will introduce you to what you need to know about working with Holt Construction, as well as the specific contract packages that are available for bidding on Newark's new Terminal A. We also want local residents to learn more about how they can work in the construction industry with Holt, as well as on other projects. As an organization, Holt Construction is truly committed to building Newark Airport together. Each of our Opportunity Friday sessions are devoted to specific topics and include an opportunity for live questions and answers. At the end of each information session, we review direct contract opportunities that you may be interested in bidding once you have pre-qualified with us. So let's get started with today's session. Legally protected companies. I won a contract, now what?
Welcome to Legally Protected Companies. I won a contract, now what? This session is focused on providing general information to subcontractors and smaller general contractors who will be self-performing specific trades. The focus will be in two parts, alerting you to some critical provisions customarily in contracts and the role of a construction attorney as part of a company's professional team. It is my pleasure to introduce Greg Chertoff, a managing partner of Pekar and Abramson's New York office, the largest dedicated construction firm in the country. He's been a construction lawyer for 28 years. He and his firm primarily represent general contractors and construction managers in transactions, risk management, project support, and dispute resolution on every kind of construction project. Greg, thank you for being with us today. The goal this morning is to have you give our audience a broad overview of a construction contract, not from a technical perspective, but from a global overview of what construction contractors should be aware of. So let's begin with, you've won a bid, you've received a contract. What should you be looking for in that contract?
First, Patricia, thanks for having me. Good morning. When lawyers look at a contract, we look at it like contractors look at the tools in their toolbox. The initial review should be mindful that everything in that contract has meaning. And if you get into a dispute out of this project, that's how the courts are going to look at the contract. It's going to try to give meaning to everything in there. And again, when we look at a contract as lawyers, we kind of divide it up into two broad categories. There's the business terms, the commercial terms. What are the price? What's the schedule? And those kinds of things. And then there's the legal terms, the risk management terms. What are the contractual obligations? What are the processes that the contract sets out for how the parties are supposed to interact? So, and being mindful of those kind of two divisions should be helpful to all contractors or anyone looking at these contracts at first blush. The commercial terms, sometimes our clients ask us to look at those. Are the liquidated damages clause consistent with what we understand is going on in the marketplace, for example? But we're not in the business of pricing construction contracts. That's your business. We're looking and asked to look more typically for what you all probably think of as the legalese. What are your obligations? What are your risk exposures? Are there limits or caps on your risk exposures if you fail to perform scrupulously in accordance with the contract? What are your rights for relief, for a schedule extension or additional compensation if changes occur or delay events occur that extend your course of performance? What are the indemnity clauses and what do they say? And an indemnity clause is a party's obligation to protect another party or make good on a debt owed by another party. And those are critical clauses. And the indemnity clauses, which are typical in every construction contract, are inextricably intertwined with the insurance clauses because those often operate together because many risks may be able to be transferred to insurance, not all of them, and the indemnity clause and the insurance related clauses are intertwined. And those have to be viewed and harmonized together. Another very critical thing that we'll talk about now and throughout this conversation has to do with the notice obligations under a contract. All contracts, construction or otherwise, almost invariably include obligations on parties to give notice to the contract counterparty if things occur. And if you don't comply with those notice obligations, in the event of a change order or extra work or delay or impact claim or many other things, you may be inadvertently waiving your rights or not preserving your rights to additional time or additional compensation if you don't scrupulously follow those provisions. So it's obviously way too much to go through every single contract clause for this forum, but that's a high-level overview of some of the things we look at first.
Thank you, Greg. Can you summarize some of the important parts of a contract?
Sure. Just going back to what we were just talking about, from a practical standpoint, what our clients, what contractors of every tier can be doing to operationally manage their risk. I'm going to focus on those. Again, going back to notice, understanding when you have to preserve your rights and how to go about documenting that. There's often strict timeframes associated with that. If an impacting event occurs, you may have a limited period of time to alert the contract counterparty. So again, those are very critical provisions from an operational risk management standpoint. Schedule, the provisions related to the schedule and your obligations to provide schedule information, to adhere to a schedule, to communicate regarding the schedule are often very critical. And you should understand that the contract form itself likely consists of many parts. There's probably the contract document, what you think of as the boilerplate, the legalese, but that likely almost invariably incorporates the plans and the specifications, which are also contract documents. And they all have to be looked at and understood in totality and how they interrelate to understand what you're actually committing to.
Great, thank you. Are there some general tips you can give contractors to avoid claims?
Again, it's the chorus you're going to hear from me again and again. Understanding your notice provisions. Understanding when you're entitled to relief if impacting events are occurring. Understand from a very practical standpoint, I often hear from our clients that they're concerned about giving notice, that they perceive that if they're going to write a notice letter or a notice email, that it's going to be perceived by the general contractor, if they're a trade contractor, or the owner, if they're a general contractor, as a confrontational thing, as a hot stick in the eye. It doesn't have to be. Tone is critically important. You could give a notice letter that says, hey, you're hurting me. This is outrageous. I'm entitled. You're wrong. I'm right. Bad faith. Or you could write an equally, perhaps more effective notice letter that says, I'm not getting this design information that's critical to me. It's threatening to impair my ability to effectively build this job timely and efficiently. I want to avoid that problem. I want to be part of the solution. But if I don't get this information by this date, these bad things may happen. How can we work together to avoid this? That type of letter probably checks all the contractual required boxes of an effective notice letter to preserve your rights, but it's a collaborative letter. And it may get a better response from whoever you're writing it to, an owner or a GC or a subcontractor, whoever is the audience for the letter. And certainly if you get into a dispute and you're before a mediator or a judge or an arbitrator, that tone, which builds your credibility, is going to be much better perceived than a confrontational tone. Almost always. There's always exceptions. But so that's a very critical bit of practical guidance I like to give to my clients. Don't be afraid to write a notice letter. Your contract requires you to do that. And maybe, probably almost always, before you send that letter, you want to pick up the phone. You want to call. This is a relationship business, of course. You want to call whoever you're going to be writing to and saying, look, the contract says I have to do this, so I'm going to. But I want to talk with you about it first. I want to figure out a way to solve these problems. You almost always get more flies with honey than you do with vinegar, and that should be a mindset that contractors should be aware of. They shouldn't be afraid of how to document things effectively. It doesn't have to be confrontational. And most contractors, look, nobody gets into the contracting business because they want to write notice letters. They want to build things. So they're often not trained in how to effectively make a real-time project record. And so that's some of the best practical guidance I think I could give.
Excellent points. Getting legal advice is a challenging process if you don't already have a relationship with an attorney. How do you find the right construction attorney for your company?
Finding a relationship with a construction lawyer is like finding a relationship with any other professional, like your doctor or your accountant. First of all, you have to be comfortable with them. You can often get recommendations from your peers. You could look to your industry trade groups. Many construction lawyers like me and my firm and others in the construction bar volunteer our time to industry trade groups to support them. That may be a good resource. You could look to your accounting firm and your insurance broker. Construction lawyers and accountants for contractors and insurance brokers and professionals often work collaboratively to support our clients. So we have relationships and they may be able to recommend somebody to you that they feel is a right fit for your firm. Those are the places I would start.
Can you explain the different services attorneys provide and help us better understand the role and the importance of a construction attorney as opposed to a personal or a general business attorney?
Sure. And before I do, let me go back to the last question for a moment, if I may. One thing not to do when looking for a construction lawyer, I wouldn't just Google construction lawyer, because what you're going to find is all the top hits are going to be personal injury lawyers that represent or are seeking to represent people who may have been injured on construction projects. And those may be fine lawyers for the discipline they do. I'm not going to comment on that, but they're not the type of business commercial construction lawyer that we're talking about looking for here. Now, thank you for indulging me for going back for a moment, but the types of services that construction lawyers provide. We provide transactional guidance to our clients when they're to review their contracts, to help negotiate them, to maximize their risk position and their business position in those contracts if we can. We train our clients and educate our clients about what all these different contract provisions mean and what their obligations they're undertaking and how to negotiate them or how to manage the risks they may be knowingly accepting. We provide project support during the life of a project. Some of the best value I feel I add and the most fun I have is when a client of mine calls me up and says, Greg, I'm having a problem on a job today. I don't want this to blow up into a big problem. Help me navigate this now to try to avoid a big fight, or if it's gonna wind up there and we can't avoid it, to help me make a real-time record with my notices, with tracking documentation, with tracking my costs. It helped me develop a strategy to deal with this in real time to hopefully avoid the dispute or to win it if we get into it. And then we handle disputes. Everybody knows construction projects sometimes have friction points and parties get into disputes, sometimes very complicated ones. And so we advocate for our clients in all manner of dispute resolution, mediation, arbitration, litigation, negotiation, to try to get disputes or ultimately get disputes resolved. That's what we talk about when we say a construction lawyer. Then there's business lawyers who provide, setting up companies and general business advice. And there's employment lawyers on issues dealing with your employees. And there's labor lawyers that deal with union issues. And some lawyers cover this broad spectrum, or some law firms like mine have experts in all these various disciplines. So you really got to focus on what you need and what your priorities are when you're targeting what type of lawyer to have.
Good guidance. But let's talk about costs now. We all know that costs for legal services can add up. What guidance do you have for smaller contractors to control their costs?
And I'm fully aware of the cost of legal services and the rate pressure and the tight margins our clients work on. So some of the best advice I could give goes back to the old axiom, an ounce of prevention is worth a pound of cure. A little investment in legal advice can often avoid much bigger problems down the line. It's hard to measure the value of it because it's hard to measure with a metric the value of a problem you avoided. But it's very easy and painful to measure the cost of dealing a problem you didn't avoid. So having a relationship with an attorney, to have them on call, not just when an issue, you shouldn't be reaching out to form a relationship with a lawyer just when you have a big issue coming up. You should have a relationship with a qualified lawyer that you could call to ask for the 10 or 15-minute piece of advice to help right the ship, to help steer something in a right direction. Because if you can do that, that'll be much more cost effective than letting a festering problem, become inflamed. Having a strategy and being proactive in managing your contracts and managing your projects with an eye toward how to preserve your rights. If you're incurring costs that you're going to claim, how to effectively document them in real time with the resources you have internally is another big piece of proactive advice I could give to avoid a lot of cost about fighting about things after the fact. If you keep good records in real time, thinking about how is a third party going to understand this record, and let me keep my records in a way that they will understand, that can save a lot of cost and expense about fighting later on.
So let's say you have that relationship set up. How should a company use their attorney? For example, if a problem arises, should you reach out to your attorney immediately, or should you try to resolve that issue without legal assistance?
I'm going to unfortunately here give you an answer that is the least favorite answer among clients asking lawyers questions. It depends. We often find ourselves saying that. A lot depends on the company's culture. And it's really a client-driven choice, how they reach out for services. In my personal opinion, having done this for nearly 30 years, there are routine problems, right? Contractors are in the problem-solving business that contractors deal with all the time. But if you're getting a feeling that this given problem may be blowing up into something bigger or more complicated or more legal, in my experience, it is almost invariably a good investment to try to make the small corrections early and strategically rather than to letting the problem fester.
Good point, being proactive. What are some tips for interviewing an attorney to determine if they're a fit for you? Can you provide some basic criteria for that, making that selection?
Sure. First of all, you should be comfortable with the person. When effective, a lawyer's relationship to their client is a very personal one, right? Clients are looking to us for guidance and the wisdom of our experience. And you have to be comfortable with the person you're dealing with, that they're responsive, that they understand your industry. You don't want to, if you're hiring a construction lawyer who purports to hold themselves out as an expert in this area, and they don't know what a change order is, or a specification is, or what a shop drawing is, you're probably not talking to the right person. They should speak your language. I highly suggest when you're interviewing a lawyer, you bring them a real problem, either one you're wrestling with now or one you've recently wrestled with, and present it to them. And say, what would you do? What guidance, what advice do you have for me on how to deal with this? Then you're going to have a real interaction with that lawyer and understand, are you comfortable with the real-time guidance they're giving you? Are you comfortable in the way they explain the problem as they see it to you? Are you comfortable with the types of solutions they may preliminarily be offering to you? And that could be a forum, and a very effective one, for really understanding whether this lawyer is actually expert in this discipline and whether you're comfortable in how they interact with you.
Small contractors have an accountant and they have an insurance broker. Can you provide some guidance on how a contractor can integrate these professionals to assist them to avoid claims?
Certainly. And I often work closely as part of a team with my clients' insurance brokers and accountants. So we each have different professional disciplines, right? But they all interact and involved in risk management and financial management. As I mentioned earlier, when we're reviewing a contract for a client and we're looking at those indemnity and insurance provisions and insurance obligations, and you may be providing your insurance, or a general contractor or an owner may be providing insurance for you in an OSIP or a CSIP. We certainly have very effective working knowledge of that as an experienced construction law firm, but you have insurance experts in that discipline, and we should be coordinating and making sure that you're properly covered in every way you can. Your accountants and your financial managers, just by way of one example, if you're making a claim and you're incurring costs that you're going to want to try to recover from the party above you or below you, whoever may be responsible for those costs, your accountants, internal and outside, can be very effective in helping creating a program on how to document your costs and segregate them effectively, so we have the tools and the documentation we need to go prove your entitlement. Those are just a couple of examples of how construction lawyers and other industry professionals can work together to bring the most value and efficiency to our clients.
Mm-hmm. Many firms also have in-house contract managers. Do you have guidance for how these in-house professionals can assist the owner and the project team to avoid claims and disputes on their projects? Absolutely.
An effective in-house contract manager is of tremendous value to a contractor. They may be a lawyer, they may be a non-lawyer, but who's very familiar with contracting processes and contractual obligations. First and foremost, I'll say a good contracts manager who engages with the project team early and often is one of the best resources for saving the contractor money. They're bringing in-house an expertise to effectively understand the contract and document obligations in an effective way. And that avoids fights, promotes recoveries. A really good contract manager should be actively working with the project team from the inception of the project. They should be training. It's their job often to become a master of that contract. And they should be at those initial project meetings with the project team, educating the project team on the various terms and obligations of that contract, how they need to maintain the schedule, how often they may need to update information, what notices they'll need to provide and when, and what those notices may require, and many other things laid out in that process portion of the contract document. And then they should be a resource to the project team in implementing those things when the need to implement them comes to pass. They should be effective resources in helping record keep and document extra work and cost and time related events. And all of that effectively manages risk and should, at the end of the day, avoid fights, make them easier to win if you get into them, and overall save money for the contractor.
Great. Those are all great points. Thank you so much, Greg. Really appreciate that insight. And now we'll turn it back over to Alex.
Thank you for the opportunity.
Good afternoon, everyone, and thank you for joining us today. Before I bring back our panelists, let's go through the current opportunities at Newark's Terminal A. Project number 1. This is a large project, 60,000 square foot ground up construction. Within this project are the following scopes of work. Early packages for site and civil are currently on the street and going out within the next 2 weeks. Scopes of work include scaffold and protection, cleaning labor, materials and equipment, fencing, site work, civil and prep, utility service work, driven piles, foundation, concrete foundations and structure, masonry for the exterior, masonry for the roof, roofing, masonry for exterior stair towers and interior elevators, structural steel and deck, miscellaneous metals, millwork packages and casework, high-end millwork, roof guardrails, wall panels and louvers, curtain wall systems, exterior and interior doors, frames, and hardware, floodgates, fire curtains, windows and skylights, drywall and ceilings, tile and stone, terrazzo, painting, walls and ceilings, as well as wall coverings, elevators, glass elevators, escalators, sprinklers, plumbing, fire protection, HVAC, electrical and fire alarm, security, debris, garbage removal, trucking and hauling, and substation equipment. This is the largest opportunity that Holt currently has, so please make sure that your pre-qualifications are submitted and approved so you can all be part of this exciting opportunity. The next project is project number 2, which is on the street now for bidding, early works as well as some support services. Within this project, it is a 35,000 square foot club and terminal fit out. The terminal fit out is on the street. The club is starting. Within this project are the following scopes of work: existing conditions and demolition, concrete, ornamental metals, openings for wood, windows and doors, drywall ceiling systems, drywall, tile and stone, floorings, which include carpet, VCT, terrazzo, painting, wall coverings, millwork, high-end millwork and casework, specialties, storefront and branded signage, fire suppression, conveying equipment, plumbing, HVAC, electric and safety and security, fire alarm. The last project is already bid we are holding bids open for the following trades. This is a 2,429 square foot concession space located inside the terminal. This is a smaller project, so if you are a smaller company, this one is perfect for you to get your feet into Newark Airport. The following scopes of work: metals, drywall, framing, ceilings, tile and stone, flooring, which includes carpet and VCT, painting, wall coverings, finish work, specialty storefront branding and signage. This is a name brand. Signage is very important for this company. Millwork, fire suppression, plumbing, HVAC, electric work, fire alarm, and security and safety. And now let me bring back our panelists, our own Patricia Zigaby, Holt CEO, and Greg Turtle from Picard and Abramson partner. Welcome to both of you. Thank you so much for joining us today. Let me get to the questions that we have. The first question is, Patricia, I think you're going to be the best to start this one. I know you both touched on it in the session, but this one is really something that Holt, as a family company, we really like to hit this one home and teach this to all of our people. So, and I always try to trickle it down to our management staff about slinging letters. You know, that's the buzzword that we like to use. So what is your advice before sending a legal letter, before involving counsel? You know, is there a way that you like that done as in our organization, something you suggest to our people?
Talk about this all the time, Alex. Of course, it always depends on the particulars, but generally speaking, whether the potential dispute is with an owner or a subcontractor, our approach is to try to always keep an open line of communication. Holt's business model is relationship driven. We always prefer to preserve the relationship if possible. And Greg touched on this a little bit. Even if the situation requires a notice letter, it's always best to first let them know you're sending a letter to preserve the contractual rights, but the goal is to come to a resolution. Holt has a long-term affiliations with both owners and subcontractors. And of course, we want to continue them. So it's always worthwhile to keep that line of communication open when you're able to. Of course, it's always good to have that 15-minute conversation with your counsel up front. That's usually worth it.
And then Greg, this next question is definitely geared to you. I always have a problem with this. You know, when do you know, as a contractor, as an individual, when should you call your lawyer? Is there like something, is there, you know, a time frame? Is there, you know, a milestone that happens when you're having, you know, I like how you used friction. Sometimes we feel as when we're in construction that friction, we're on fire. So before the house burns down, Greg, when is a good time to call you?
Well, as I said before, it really depends. And much of it is gut intuition, right? Contractors deal with problems every day on every job. You're contractor solving people. So trying to be able to intuitively distinguish between this is something that's just routine and I can handle myself versus this may be something that may be of greater consequence. There's no flow chart or process I could create for that. But certainly there are some red flags. If the other party seems to be acting out of character, right? If they're escalating things, well, then maybe that should give you pause. If it's a potentially major issue with major time or cost consequences, of course, you should be giving it special attention and special due. But fundamentally, if your gut is telling you this may be a problem down the road that may be of substance, it's probably worth reaching out to your counsel. And again, if you have an established relationship with a lawyer, you're going to be more comfortable picking up that phone and having that few-minute conversation. And your lawyer, a good one, should be able to help you in that initial call. Okay, I really think this is something, you know, here's a little bit of guidance, handle it on your own and let me know if you need me again. Or, oh, I've seen this kind of thing before. This could be a big problem. We should really talk about it more.
Right.
I could tag on that, Alex, too. If you've already received a letter from a lawyer, of course, you want to pick up the phone to your lawyer. You definitely don't want to address that. But if it's just like an email or a phone call, and you feel, and it's not an aggressive one, and you feel confident that you can have that conversation. But if it's something that you're questioning about, you can easily have that informal conversation with your lawyer up front and then make the call.
Sure. And just jumping in on top of that as well, some tips to make that call with your lawyer more efficient and less costly for you. Have your information ready, right? The lawyer is going to ask a bunch of things almost always. Show me the contract. Show me any other relevant documents that you have related to this issue, be it plans or specifications, or if there's already been communications, letters or emails or meeting minutes related to this issue that have gone back and forth. If you have that all assembled and you could point to the things that you think are important and package it up and hand that to your lawyer, that'll facilitate an efficient conversation about those things.
So, I being on the project management side, when I started working at Holt and growing up at Holt through the many different titles that I've had and responsibilities, I've learned over my time to not fire off the first letter that really comes, the first email that comes out of my head. Right. So I've learned that as I've grown in the industry, and you both have different styles, Patricia being a woman and Greg being a man, we have intuitive different styles that we use. What are your best tips before sending that email, in anger to a sub or to a client? I know you both have a history and you would have some good tips for us for that. Greg, would you want to start?
Sure. A few tips. First, I wouldn't send anything out of anger. Nothing should be sent out of anger or frustration. If you're angry or you're frustrated, you shouldn't be sending anything. You should be taking a step back. Everything you do should be strategic and thoughtful, not a knee-jerk reaction or out of anger. You're making a record here that every communication you send to your counterparty, a subcontractor, a contractor, an owner, whoever it may be, is the record that you're assembling about that issue. And so it should be thoughtful and strategic. You should be thinking about all the different audiences you have for that communication. If Holt is writing to an owner or is writing to its subcontractor, those are the obvious audiences, right? The owner, the recipient of the letter. But also be thinking about if this issue becomes a dispute 2 or 3 years down the line, that email or that letter could be evidence that the lawyers are using and presenting to a judge or a jury or an arbitrator. So be thinking about those multiple audiences, and that audience may be entirely disconnected from the series of events that have occurred. Think about including a little more context about the issue than you would normally include to somebody like that you're in the middle of a conversation about, right? That little extra effort will put things in context for those other audiences later on. And really think about, what are your goals? What am I hoping to accomplish by writing this? There should be a strategy and a thoughtful one about anything that you're doing in that regard.
So also, you should make sure that you have the facts. Don't assume that you have the facts, because we all know there are a lot of parties that come together to build a project, and sometimes you don't actually have the full picture. So it's important you first get the full picture. And then the other thing that I think is helpful, if you try to walk in the other person's shoes so that you understand why they're taking this approach. I mean, if you make the assumption we're all just trying to do our job, right, and get the project done. So I would say, try to walk in that person's shoes, and why are they taking this approach?
Great. And what I always say is, I always tell everybody to draft their first email and just leave it in your drafts and wait a couple hours and then tweak it again, and then wait another couple hours and then tweak it again before firing that email off, because someone could be added to that email that you don't want to see you act in that manner. So you always have to be careful what you do in writing and send out to people because you are on a stage per se. Greg, next question was going to be for you. You're probably going to say yes because you are an attorney. Should I have a construction attorney review all of my contracts before signing them? Are there certain contracts that you think should definitely be reviewed? Like, what if they get a small contract? What do you think?
So I'm not going to say yes in every circumstance. I'm going to give a more standard lawyer answer. It depends. It certainly size of the contract, complexity of the contract. If it's a new type of work you're doing or a new form of contract that you're not familiar with, those are things that may drive you to consider seeking outside counsel. And a lot depends on your given experience and comfort level in understanding the contracts. People who are entering into contracts as a fundamental basis should understand their contracts and understand what they're getting into. And a lot of people don't in every industry, right? Every word and clause in a contract has meaning and will be given meaning if you get into an argument about it. So some non-lawyers and people in procurement and in contracting groups and contractors are very sophisticated and really do understand it all, and they can handle an awful lot on their own. And clients come to me to teach them about all those different parts of the contract so they could do a lot of it on their own. But if you're venturing into something that you don't understand and that you're not familiar with or you're uncomfortable with, you really should be considering reaching out to counsel for guidance.
And also, is it a repeat client? Have you already signed that client's contract, completed a project, successfully completed that project, and now you're faced with another project and the same contract?
Great. Patricia, this one is custom for you because you used to be our general counsel, so you know all of the pitfalls, and you always speak the mantra to our teams about documentation. So what is the most important documentation? I know you tell our supers about their dailies, pictures. What are your top ones?
Absolutely. The first thing your counsel is going to say is, don't tell me the story. Let me read the story, right? So it's daily logs, meeting minutes, the contract, any plans, all documentation. Your lawyer's not really going to want to hear the story. They want to read the story.
Okay. And Greg, what about for you? What are some things, documentation that everybody should do no matter what on their projects?
Well, if you're resolving an issue, a change order, for example, make sure that you're actually documenting a complete resolution. Right? So don't let things linger out there, right? Change orders are routine on every construction project. Make sure that the change order resolves all the issues related to the change order, time and money and scope and whatever else may be involved, and make sure it's very clearly documented. The last thing you want to do is think you've resolved something, but not have done it clearly and leave yourself a time bomb for a later fight that you thought that was already resolved. So that's a big issue. Notice is one of the most important things. I touched on it before. Every one of these contracts require all the parties to give notice in the event that they're being impacted or may claim additional time or money or anything like that. So documenting notice in accordance with the time requirements and the substance requirements of your contract, that's probably the most important piece of documentation.
Great. The last question that we have for today is, we are already pre-qualified with Holt Construction. Does this mean we should be listed for all projects, including Newark Airport? So I'm going to answer that question. So yes, so if you are already pre-qualified with Holt, your pre-qualification is approved, whatever state that you are pre-qualified to work in, when you fill out our building connected application, it does ask you New York, New Jersey, Connecticut. Remember, Holt's a national firm, so wherever you want to work, we'll work with you. Make sure you check that. If you are not getting a opportunity yet, if you haven't seen one, it's always the thing that I tell everybody every week. The squeaky wheel gets the grease. So send an email to the Holt email address at ewrta@holtcc.com. And one of our people from the New Jersey branch of Holt will answer your email. We'll let you know if there's an opportunity, and we'll ship you over to our estimating group so they can add you to their bidders list if you are not there already. I got another straggler question. Next one. We are looking to work on project 1, 2, and 3 for wall coverings, branded signage, etc. Please let me know how we can receive these packages. We are already a vendor with Holt. This is our last question. So it's the same answer that I gave. If you have not, the signage packages for projects 1, 2, and 5 have not been released yet. So that's why you might not have seen that. The wall coverings, that is definitely released already for 5. Painting has been released for 2, but not wall coverings or paint for project 1. They're all being phased because, as we know, the terminal is still under construction. So shoot us an email. Our consultants put it in the chat. It's ewrta@holtcc.com, and we'll pick up your email and send you the information you're looking for. Also, if you're looking to pre-qualify, if you have not pre-qualified with us yet, please make sure you send an email requesting our pre-qualification package to that same email address. Let us know what trade you're interested in, and we'll send you off the link so that you can join our Building Connected system and complete your pre-qualification. Make sure, if you guys have any questions that you might have been a little shy to ask, I know having 2 attorneys on our panel might be a little scary, but if you have any questions that we didn't get to today, please feel free to also email them to us. A copy of today's video is going to be on our outreach website for everyone who attended and those who registered and not attended, so you can get the information again if you might have missed something. I want to thank Greg and Patricia. This was a wonderful session. I think it was very informative, and you helped a lot of people today demystify a contract and hiring an attorney and what they should know. I want to invite all of you to join us next week for another great Opportunity Friday session on insurance, which will demystify coverages and provisions contained in your policies, what coverages you need on an airport project, on a construction project, what the limits are that Holt requires on their projects, and why. So Alliant Insurance is going to be here next week, next Friday, same time at 12 o'clock. So please register for that and join us and answer. We'll be there to answer any questions. I'm going to present you again live opportunities, and you'll be able to ask your questions. So have a beautiful weekend. The rest of your day, the sun is shining. Thank you all for joining us. Thank you, Greg and Patricia. Have a great weekend.
Thank you, Alex. Thank you, Greg.